Welcome to this presentation covering the topics of downsizing and post-termination issues with a side discussion of non-competes. So that's our topics for today. Let's get started. We're going to discuss downsizing generally, and there's four particular issues that we're going to focus on. One is what happens when we are downsizing and our workforce is unionized. Another issue arises when we're doing a significant amount of downsizing, especially a unit closing, but this issue also arises in other contexts, and that is compliance with the Warren Act. And then we'll also discuss the issues that are peculiar to downsizing as they relate to age discrimination and the Older Workers Benefit Protection Act. Finally, we'll touch just briefly on the topic of bankruptcy. Sometimes when a downsizing is occurring, it's because the company is failing. Maybe the company will survive, maybe in part due to the fact that it was able to downsize, but sometimes things don't work out. And so we will also consider what the rights will be for employees if the company ultimately fails. From a post-termination perspective, we're going to discuss unemployment benefits and we're going to discuss restrictive covenants. Restrictive covenants aren't exactly a post-termination issue because we have to have entered into the covenant with the employee either at the time that the employment began or during the course of the employment. But whether those agreements are enforceable often comes up in a post-termination world. So this is a little bit broader topic than perhaps the title suggests. Let's get started. Downsizing. What do we mean when we say downsizing? This is an example of kind of HR doublespeak. We're using a euphemism to say we're firing a bunch of people, but we're firing people who pretty much did nothing wrong. We're not firing them because they messed up. We're probably firing them because senior management messed up. Senior management did something that caused the business not to be as successful, and as a result, there needs to be fewer people on the payroll. Now, I say that that's how downsizing happens, but I would be being naive if I said that's the only time downsizing happens. The reality is, in corporate America now, sometimes downsizing happens even when the company is doing well financially. The company, though, concludes that it could do just a little bit better if it had a few fewer people in this department or that department. So the issue of downsizing is broader than just a struggling company. So when we see the term downsizing, we're talking about reducing or the size of the population of employees. Another common term for this is reduction in force. And the force here, of course, is the labor force in a particular organization. And oftentimes this is referred to as a RIF, and it's kind of used either as a noun or as a verb. The RIF is going to happen in January, or he was RIFed from his position with that company, that type of thing. So that is the terminology and kind of what they mean when we use those terms. So what constraints does an employer have in making a downsizing decision? For the most part, the employer is pretty free. Keep in mind that in most work environments, the employment relationship is employment at will. Let me just write that up here. And I've said this about 400 times. So this isn't going to be some new information. It's pretty tried and true. But if the workforce is not government-based and it's not unionized, the employees are very likely to be employed at will, unless they are very senior managers. Well, since the employer has the legal right to end the employment at any time, with or without notice, as long as they do not downsize or terminate for an unlawful reason, it's a perfectly lawful activity to have. So in the non-unionized workforce, there's relatively few constraints on downsizing. Now, that doesn't mean that an employer wants to do this willy-nilly. There are definitely real concerns in downsizing, concerns that are in many senses greater than when we're doing an individual termination. And we'll talk about those. But conceptually, an employer who is trying to decide whether to downsize and how extensive to make the downsize is relatively free in making that decision, even though the particulars of the decision may run afoul of this or that law, or the employer may need to have to jump through certain hoops in order to come up with a compliant process. But let's talk about the scenario when we have a unionized workforce. So this is in the non-unionized situation. Typically in a unionized situation, there's going to be a collective bargaining agreement that the union and the employer has negotiated. And that's going to have set terms in it. Well, one of the things that may be addressed in that collective bargaining agreement is how downsizing might occur. Even if it isn't discussed, it can be a topic of negotiations. There's a bit of debate in the legal community whether downsizing is a mandatory topic of bargaining or just a permissible topic of bargaining. If it is a mandatory topic of bargaining, the employer is required to negotiate over that with the union. So let's say the employer concludes, gosh, we're gonna have to do a layoff, or we want to do a layoff. And so under those circumstances, if it's a mandatory topic, it has to negotiate with the union before it can actually implement the decision. If, on the other hand, downsizing is a permissible subject of bargaining, then the employer can negotiate with the union about it, or the employer can just go ahead and act unilaterally. Um, it's unclear right now what the law is in this area, and so I certainly would recommend, if you happen to have a unionized workforce that will be affected by the reduction in force, that you consult with a labor attorney to see exactly where the lay of the land is on this issue and what the legal responsibilities are for the employer. Even if it's a permissible topic of bargaining, it may be advantageous for the employer to still engage in negotiation under those circumstances. It would simply mean that the employer would not be legally required to do so. But I think a more prudent course of action when we're living in this environment where we're not sure which category it is to go ahead and engage in bargaining on this point. Of course, you may be concerned about the time constraints involved. Many times when a layoff happens, especially if a company is struggling, the decisions may need to be made very, very quickly, and engaging in negotiations may slow down that process. So there could be some costs associated with agreeing to bargain collectively under those circumstances. Downsizing, of course, can be a ULP if it's done because the employer wants to somehow intimidate workers or reduce its unionized workforce. Imagine that a company has 4 facilities, A, B, C, and D. And this facility is unionized, D is, and A is unionized. The company is having some tough times economically. It knows it needs to close one of its facilities, maybe even 2 of its facilities. It may decide, well, gosh, we don't really like the union, so why don't we just pick D? Make that go away. And if we need to get rid of 2, why don't we pick D and A? And if the basis for the decision to eliminate D and A is that they are unionized facilities, then that would be unlawful under the NLRA. If, on the other hand, the union says, or excuse me, the employer says, listen, we think that this unit happens to be less profitable than C and B, and that's why we want to close it. Or perhaps this unit has less state-of-the-art equipment. These others are cutting edge, and so we would want to get rid of this facility before we get rid of these facilities. So in that situation, the company would have an argument that it really isn't the fact that this particular facility is unionized that is causing us to want to close this facility, but for some other purpose or some other reason might be motivating it. And so that becomes a complicated issue of what is the true motivation. And certainly the union is likely to come in and say that's not the true motivation. Your true motivation is you want to break the union. And so that would be an issue for possibly could result in a ULP charge that would be prosecuted through the NLRB process. Another way that these issues sometimes come up is that, let's imagine that there is an ongoing, let's say there's a 5th plant over here. There's an ongoing union organizing campaign. Well, the company might say, oh, wow, we want to nip this in the bud. So there's already some talk of union activity, well, we might go to that facility and say, hey, you know, we're thinking about downsizing. And the workers might start thinking, ooh, wow, we better drop this union talk because we don't want to be the facility that's closed. And that's how we interpret what the company has just said. So you can see in that situation, it could be a ULP under those facts. But there is no requirement that the company keep open a facility that it has decided is not a good business judgment, as long as that judgment is not based upon the unionized nature of the facility, and as long as it is the subject of bargaining if it, in fact, downsizing is a mandatory topic of bargaining. As we already said, employers can choose to go out of business entirely, but it cannot selectively close facilities to inhibit unionization at the remaining facilities. So if the purpose is to have a chilling effect, for example, they close these two facilities because they're hoping these two facilities will not go union, and they will assume, well, the workers will figure out why we closed these two because they were unionized. That would be an unlawful function there. So that's a little overview about how labor law affects downsizing. But most likely your facility, if you work in the Dallas area, isn't going to be unionized. So if it is, you'll want to be sure to discuss labor law with an attorney who does labor law if you are considering a downsizing that could affect employees in a unionized facility, or one that appears to have been considering unionization. Let's talk about the WARN Act, which stands for the Worker Adjustment and Retraining Notification Act. And you can see our Congress cleverly came up with an acronym that captures the meaning. The WARN Act warns or alerts workers to the fact that their employment is about to end. The reality is that in an employment at will environment, our jobs are always at risk to some extent. But sometimes an employer knows, sometimes weeks in advance, that an employment situation is going to terminate. And that employer may leave the employees in the dark. Well, in the interim, employees may have made some choices. They may have, bought a house. They may have made a major investment. They may have foregone other employment during that period of time. And as a result of their lack of knowledge, they end up making a decision that puts them in an adverse situation when the actual layoff happens. And so what the WARN Act is intended to do is not so much discourage the manager or the employer from doing the downsizing, or from telling the employer that, no, you can't do this, but simply to make sure that the workers know as soon as possible, with as much notice as possible, that this is going to be happening, to allow them to start making that transition as soon as possible. So workers covered by the WARN Act are prohibited from ordering plant closings or mass layoffs. And we use the word plant, we mean facility. It doesn't have to be a factory. It could be an office building. So employer can't close a facility or conduct a mass layoff until the end of a 60-day period after the workers receive written notice that they are being affected. They're going to be laid off. And the notice also has to go to state and local officials. Here's a link that talks about, here we go. So when you click on that link I just showed you, this gives you an overview of which businesses are covered, how you go about deciding whether you're having a triggering event or not. I'm not going to get very granular here, because the reality is when you're going to do a layoff, on your checklist of things to think about is, does the WARN Act apply? And if it does apply, what do we need to do? So the key things to keep in mind are, you need to start notifying people at least 60 days before. And again, the purpose is to give those families the opportunity to start looking for alternative employment. It applies to fairly significantly sized employers. They must have at least 100 or more full-time employees. Sometimes it can be included in that group some part-timers if the number of hours worked adds up to that component. You can see in this case, you might have some workers working overtime, some workers working part-time. Now, I will let you know that the 100 employee threshold is a little tricky with WARN, because what oftentimes happens when we're doing a WARN Act is the business is failing. And so, the business starts out with an employee population up here, and then it does a little layoff, and then another little layoff. None of these are sufficiently big to trigger WARN Act. Then maybe it does another little layoff. And the issue is now they need to do a big layoff. They're going to have to go down here. And this drop is something that might trigger the WARN Act. The issue is, though, do we consider employment levels at this point? And at this point, they may be below the 100, therefore the WARN Act doesn't apply. Or perhaps we consider the employment level back here when the employment was at its highest and it was at over the 100 employee level. Well, if that's the case, then yes, you would need to send the WARN Act. It's a good idea to err on the side of sending it because it really doesn't cause you, the business, a lot of upheaval. It's a relatively inexpensive statute to comply with. Probably the most difficult part of complying with the WARN Act is getting all of your ducks in a row that much before the day that you actually want folks to leave. There are actually some good sides with doing the WARN Act in that giving folks 60 days, then you typically start losing your population pretty quickly as people find other employment. And so what you might find is your unemployment experience rating isn't as hit because people find employment, so they go directly from working for you on Monday to working with their new employer on Tuesday, and then there's no unemployment claim that gets filed. There's less upheaval for the employee, so it can be a win-win. But you have to get all of those ducks in a row as soon as possible to get them the 60 days. What happens if you can't give 60 days notice? Well, there's a couple of circumstances under which you are excused from providing 60 days notice. One can be in cases of natural disaster. Let's say the reason that you're closing this facility is that it burned down or was swept away in a flood. Well, under those circumstances, you obviously don't have 60 days notice before the flood or before the fire, and so the failure to give notice under those circumstances is going to be forgiven. Another thing that can happen is there can be some catastrophic effect to your business. Imagine, for example, that your business has, we'll say, 3 big customers, and those 3 customers together generate, we'll say, 60% of your business. So each one generates, about 20%. You have a good long-standing relationship with those employers, but when you enter into a negotiation with one of them, the negotiations go south. Maybe that particular, I'm calling employer, that vendor, or that particular customer might be experiencing financial difficulty itself, or perhaps it just wants to go a different way. And so you lose that business. Well, that's 20% of your business. You're probably going to need to do layoffs under those circumstances. But you didn't know that the contract wasn't going to go through. You may have had no inkling, and even if you did have an inkling, you hardly want to publicize to your employees that you might not be able to continue this contract. After all, what if you are able to continue it? You might lose some of your best workers who leave your place of employment for another opportunity. Or perhaps word will get to this customer, oh, well, you don't think you're going to be able to have a contract, and it may have some negative implications upon the negotiation. So again, there can be some catastrophic business implications that can affect whether you can continue on. And under those circumstances, you can see why it may not be possible to give 60 days notice. So those are 2 categories of situations in which there may be some issues about whether you have to provide 60 days notice or not. If an employer chooses not to give 60 days notice for whatever reason, let's say that they give notice 40 days out from the date that they're going to close the facility, and let's say they don't have circumstances that allow them to use one of those exceptions that we were talking about before. What's typically going to happen is that the employer is going to have to pay those employees who are downsized for those 20 extra days. So they get 40 days on the payroll, they're supposed to get 60, those extra 20 they'll have to pay, almost like a severance payment. But they won't be able to get a release or anything like that from it. So as a result, again, it's an advantageous thing for the employer to get the notice out at least 60 days before, even maybe a few more than that to give yourself some breathing room, but certainly 60 days is a good rule of thumb to follow. Let's consider the term plant closing. This is a permanent or temporary shutdown of a single employment site. So again, the word plant here to me implies maybe a manufacturing facility, an industrial facility for sure, but it could also include any single unit workplace. Could be an office building, could be a factory, any place where there's a significant number of employees. And when that shutdown results in employment loss during any 30-day period of at least 50 full-time employees. So 50 full-time in the plant. Now again, this particular plant might have 4,000 workers. So 50 may not, I mean, we call it a plant closing, but, oh, sorry. I'm sorry. The whole plant has to close. I apologize. I was getting ahead of myself. I was about to start a mass layoff, but no, the whole plant closed in this facility. But the plant was big enough that it had at least 50 workers. So let's say you had a plant that only had 40 workers. Well, even though the plant is completely closed, it's not going to qualify as a plant closing. But another situation that can arise is the mass layoff. This is a reduction in force that isn't related to a plant closing. For example, there may be multiple units that are covered, or perhaps you have one really big unit. And under those circumstances, maybe again you have that 4,000 person unit. Well, if you lay off 500 full-time workers off of that facility and you're down to 3,500, you obviously don't have a plant closing, but you would likely have a mass layoff. Now, this number of 500 is for really large employers. It can also be at least 50 full-time employees when these employees comprise at least 33% of the total workforce at a work site. So if you have, say, a work site of 150 workers and you lay off 50, well, you're laying off 33%. But let's say your workforce was 200. Well, now you're only laying off 25%. And so that, and you're still laying off 50. So then that's not going to trigger a mass layoff or a plant closing. I guess what I want to capture for you is that this is a pretty careful analysis that you have to do. Sometimes what qualifies as one plant versus another plant may be also an issue. Let's say in one community you have two facilities. It may be that you have workers who work sometimes at this facility, sometimes at this facility, or there may be a regular switching of labor back and forth. There may be a lot of contact between these two facilities. Maybe they share management. Maybe there's one big boss over both facilities. Well, there could be an issue about, are we talking about two plants or one plant? So there's a fair number of issues to consider as you're considering the WARN Act. And to decide kind of how you want to handle this. You can take a more aggressive position that says, well, we don't want to issue a WARN Act unless we're sure we need to, and we'll just take the financial pain if it ends up that we should have done something more but we didn't. Or you can take a more conservative approach, which is the one I would recommend, because the WARN Act really doesn't cost you much. Go ahead and issue it, even in circumstances that it may not technically apply. Your former employees are going to be thankful for that. It's kind of the kind and compassionate thing to do, and it's a relatively low expense for the employer to go ahead and do that. We're not going to talk about this case. Let's talk about what this WARN Act notice needs to be, the thing that you need to generate 60 plus days beforehand. We have to describe the employment site. You have to have a contact person. So typically this is for the government, because you send this notice also to the government can reach out to. The purpose of that reach out is that many times the state or local government will want to hold some kind of job fair or have some kind of unemployment processing feature associated with this so that they can get the employees back to work as soon as possible and get the employees access to all the benefits that they need. And so obviously the governmental agency needs to have somebody that they can contact to say, hey, this is what we want to do. And usually employers are appreciative of those efforts by the government to assist the workforce in the transition. So it's usually a good thing to go ahead and cooperate to the extent that it's possible. You have to state whether it's a permanent action or a temporary action. Usually it's going to be, you're going to say it's a permanent unless there's pretty clear evidence that it's not going to be a permanent. and you want to make it clear whether the entire plant is closing or whether we're looking at a mass layoff situation. And this is the tricky part. Up until this point, you're thinking, no big deal here, right? Well, you need to provide the titles, the positions, and the names of the people who hold those affected positions. As you can imagine, when you are preparing these lists for a downsizing, unless it's a unit closing, but even then you have this issue somewhat, there's a lot of dotting the I's and crossing the T's in getting this list correct. And so it does involve some attention to detail. Now, even in the case of a plant closing, there still can be some issues about how we're going to proceed in that area. For example, it may be that you're going to move some of the employees to another facility. Maybe your very best employees or your employees with specialized skills or your management employees, you may be offering an alternative assignment for them. You may have differing end dates. It's pretty common to phase folks out in a gradual process. So maybe you announce on this day we're going to close the facility. There's going to be this period of time here. We'll call this a 60 days where you're maintaining everyone's employment, and then you start dropping the employment. And you may keep some workers around to the end. Let's say this is a retail store. Well, at the beginning of when this is announced, you're going to have a lot of discounting, a lot of probably foot traffic as customers come in wanting to buy stuff. So you're going to need most of your workforce. You may even be offering overtime under those circumstances. But the shelves are pretty picked over by the time you're getting here, and so there's much less need for staffing under these circumstances. So you're likely to keep just a small population near the end. If you let people go before you get to the 60-day point, then these folks here that you let go before would be entitled to this pay that they missed out on that would have taken them to the 60th day. Let's consider ADEA, the Age Discrimination in Employment Act, and one of the amendments to the Act, which is the Older Workers Benefit Protection Act. Probably the most concerning discrimination statute when you're dealing with a downsizing situation is the Age Discrimination in Employment Act. I have in my career been involved in probably dozens of reductions in force and Warren Act type situations. And invariably, unless it's just a pure out unit closing and everybody's gone from a particular facility, almost inevitably the older workers are more adversely impacted than younger workers. It's just kind of the nature of the business. Let me present to you some reasons why that can occur, some reasons that aren't discriminatory. But certainly, of course, I'd be being naive if I had to there's no discrimination in employment, and it certainly can be the case that older workers can be subject to discrimination. So there's kind of two general ways that a downsizing that isn't related to a plant closing plays out. One way is I'll say three ways. One way is position driven. An employer may be eliminating a certain level of position within a facility. For example, let's say that within a facility there are 4 levels of management. We have our plant manager, maybe a staff level below that, supervisors below that, and working people down here. Well, as part of the reduction of force, the decision might be, well, let's just get rid of this entire layer. Everyone who is in this role, whether they're the best ever or dreadful, are out of here. We're not offering them a promotional opportunity to level up here. We're not offering them an opportunity to demote. Everyone's gone from this level. Well, I mean, that's pretty easy to defend. That's from a legal standpoint, attorneys like that because it's unlikely to be discriminatory, honestly, because if you get rid of everyone, now, of course, if this particular part of the population happens to, for quirky reasons, be skewed toward older workers or be skewed toward women or be skewed toward a particular minority group, I suppose there could be some impact. But most of the time that's not going to be the case, and so you're going to have a really pretty free ability to go ahead and act in that way. So you can do it through position elimination. The problem with it, though, isn't a legal problem. It's more of a business type problem. There's probably some pretty darn good people in that group that you don't want to lose. that you were probably grooming for the next level up. And so many times management will say, well, yeah, we agree we need to get rid of this middle layer, but we want to keep Bob here and we want to keep Sally. The rest of them, we're good getting rid of them, but these two we want to keep. And so now we're picking and choosing who is going and who is staying. And so we're in a different environment than get rid of everybody in this particular classification. And so now, we're moving beyond the just get rid of everyone in a particular classification. The next approach can be, well, let's base it upon seniority. The longer the person has been here, we'll retain those folks. So it's kind of a last in, first out, kind of an accounting, the LIFO rule, in other words. This is also relatively defendable because it's, number one, it's easy to apply. There's not any subjectivity. And usually older workers are going to benefit from this situation because typically older workers, began their professional career at a younger age. It's always possible that this is not their first place of employment and that they may be a recent hire, but still it's going to skew to a younger population in terms of who's affected. Now, when you do a LIFO type reduction force, it can tend to discriminate or impact, disparately impact minority groups and women more so, because sometimes those groups have made more inroads in the employment population, especially going up the ranks within an organization that is more recent. Maybe there had been a lot of systematic discrimination until relatively recently, and so now these groups are just beginning to populate this rank. And now, because you're doing a last in, first out, they're the first people who are going to lose their jobs. So there can be non-age related discriminatory concerns about a seniority system. Having said that, it's a very defendable approach to take in the vast majority of cases. So it's something that the attorneys are going to like, but management isn't going to like it, because of course the longer somebody has built the organization really doesn't have much to do with how good they are at their job, and it actually can be an indicator that they aren't good at their jobs. Let me give you an example. So let's say in this level we have 4 workers. We have Amanda, Bob, Carl, and Sally. Amanda joined Bob joined the department 6 months ago. Joined the company. He was an outside hire. Boy, he had a lot to learn at first, but he just hit the ground running. He's so impressive. He's so smart. He's so conscientious. He works a lot of time beyond what anyone would ordinarily expect. He's not ready for a promotion today to the higher level, but gosh, he is a really strong contender. And we would definitely see moving Bob up in the near future. Sally, she's been with us for 3 years. She's seasoned now. She knows what she needs to know. So in many senses, she's more ready for the promotion than Bob is. And she's also really strong. She makes good decisions. She's very dependable. She knows the business. She's conscientious. She's also awesome. When an opening comes, she would be a very, very strong contender. Carl, he's been with us for 20 years. He's not bad at his job, but there are several people that have been promoted that had less seniority than Carl. The company has time and time again decided Carl's good enough to stay where he is, but he's not going anywhere. He's topped off at this point. And if he's still here in 20 years, when he has his 40th anniversary, if he's still with the company, he'll be doing the same job. He's not going up. Amanda's been with us for 15 years. She's better than Carl, but she's no rocket scientist either. It's not that the employer would never consider promoting her, but certainly if the company has someone like Sally or someone like Bob, it would be a no-brainer to promote Bob or Sally over Amanda. And to be honest with you, there have been opportunities in the past that they could have promoted Amanda, but they didn't. And so these are 2 people who have been passed over. And if you've been passed over once, you're probably just going to get passed over again and again. It may be because there's some kind of latent form of age discrimination or other type of discrimination. And it could also be they're just not that good. And so you can see how if you have a seniority-based layoff process, it's going to capture the earlier hires. And let me say there was another person. Let's say that we also had Dan. Dan was hired a year ago. Dan's not that good. I mean, he's not terrible, but he's fairly lazy. And he doesn't do any more than he needs to. He doesn't know any more than he needs to. He kind of just goes along. It probably would be that the employer would like to see Dan go first. He doesn't have a lot of service. He's never gonna get to be a good person. And then if the company had its choice, it'd probably pick Carl next. So sometimes the new hires will include some people that aren't very good, but it will also include people who are very good. But the really long service people are usually not going to be so awesome, otherwise they would have been promoted. So that's the reason why employers usually don't like LIFO systems. The third approach, so we've talked about getting rid of everyone in a position, basing reductions in force on seniority, and then the third is basing reductions in force upon job performance. And the most common way to do this is to look at historical appraisals, and there's lots of different systems for doing it. One way can be looking at the last year's appraisal. Well, it can be looking at the last 3 years or the last 5 years of appraisals and figuring out who has gotten the best ratings over that period of time. And the appraisals themselves can be a variety of focus. And you can just do, usually in an appraisal, there'll be several different numbers or grades, and those are combined in some kind of final grade. And you might take components of that and put more emphasis or less emphasis upon them to come up with some type of equation. You can see if you look at the appraisal system, Bob and Sally are probably going to have the best appraisals, but Bob might be in a bit of an awkward position because he hasn't been there a whole year. And so his appraisal history will not even include one annual appraisal. So many times under those circumstances, the reduction in force protocol will say, you got to get rid of him. He just doesn't have enough service. Dan might not have enough service either, so he might be an automatic go. Sally probably does, and so if you're trying to get rid of one more person between Sally, Carl, and Amanda, these three folks would probably have enough history that they could be compared with one another. Sally probably has the best appraisals, Amanda has the next best, Carl would have the worst. So in this situation, we'd probably say goodbye to Bob, to Carl, and to Daniel. And so that would be one way kind of it working out. So what are the risks associated by having some kind of a job evaluation process? Well, if we use historical appraisals that were completed before the employer or the manager knew that a reduction in force, that these might be used for a reduction in force, those can be pretty good. Not bulletproof, but pretty good. Of course, this is helped if the employer has a good evaluation process with lots of checks, with lots of objective performance goals and things along those lines. Again, if you have a very subjective appraisal system, then that's not so good, and it can present some real problems. Another issue can be if the last appraisal is being considered, especially if the people completing the appraisal had reason to suspect that this might be used in a reduction in force. So if a reduction in force was kind of in the whispers at that time, then you can see managers saying, well, I want to protect that person, and so I'm going to give him the good appraisal. I don't want to protect that person, so I'm going to give that person the weaker appraisal. So that's one of the reasons why you typically want to keep a reduction in force pretty quiet as long as you can, especially if you are in appraisal season when these are being completed. You want to have consistency across appraisals if you decide to use this for reduction in force. This is especially helpful if you're going to have multi-unit reductions in force where you're comparing people. So let's say there are several units in this particular part of the country, and you're thinking about getting rid of some in lots of these different units. And so in some sense, Bob and Amanda and Carl and Sally and Daniel are competing against their counterparts in another unit. Well, if you have a really easy appraisal grader in that other unit, you can see how that really wouldn't be fair for people in the unit with the hard grader. And so having some consistency so that, you know, a rating of 4 means the same thing in Unit 1 and Unit 2 and Unit 3, and a rating of 2 means the same thing in Unit 1 and 2 and 3. You're never going to be perfect with it, but you want to have some checks to have a consistent process in effect. And one way to do that, of course, is having some kind of force system. 10% of the population gets this rating, 20% gets this rating, 30% gets this rating. That does kind of force there to be more consistency. Okay, determining whether a discharge is part of a reduction in force is not always straightforward. Here's a dirty secret. It's not a secret at all, but it's something that is an open secret sometimes, and that is that sometimes employers like to get rid of problem employees, lazy employees, difficult employees, and they use the RIF process that might otherwise be a valid process to get rid of those folks. So going back to our example, let's say that it's pretty obvious that Bob is going to go and Dan is going to go because they're newbies. You'd really like to see Carl go. And now you're trying to decide, well, do I RIF 3 people out of this department or just 2? And you think to yourself, I can just go ahead and make it 2. And that solves the problem with Carl for me. Well, is that really a reduction in force, or are you deciding I'm firing Carl because of his poor job performance? You can see how that's really on the edge between those two positions. It's easier to fire Carl in this situation for several reasons. For one thing, it's easier for Carl. I mean, being riffed is not a day in the park, but it's a lot easier on one's self-esteem than being fired. You can hold your head up high and kind of go about your life, and your ability to find other employment is not going to be directly impacted nearly as much as being fired. And so it's a good thing for Carl. It's also easier for the manager. I mean, even if the manager doesn't like Carl, nobody likes to fire somebody saying, you're out of here, you're a bad person. That's not a pleasant thing to do. Number 3, the manager may not really have a basis for firing Carl. Carl's not great, but he's not breaking any rules. He's not doing anything he's not supposed to do. He's okay. Mediocre maybe, but okay. And so the manager may feel that he doesn't have a basis to fire, or that his more senior management won't support him firing Carl under these circumstances. So he's looking for kind of a bit of a tricky way out of his Carl problem, and this he might see as a solution. So let's say that Carl goes bye-bye in the RIF, and it's described to him as a RIF. And then 4 months later, they've hired, you know, Edwina to take what appears to be Carl's old job, right? Oh, well, didn't actually need to get rid of Carl, I guess, after all. But the employer doesn't call Carl back. Hey, Carl, we decided that, you know, we actually need somebody in your position, so we're bringing you back. No, that's not what's going to happen. They're going to hire a new person or promote someone else from within to take over Carl's old job. The general rule of thumb is if that position is replaced within 6 months, it's not a true reduction in force. It was a termination. If it's more than 6 months, it's probably going to be considered a legitimate reduction in force, especially if you at least tweak the borders of the new job. Maybe maybe Edwina has a little bit greater responsibility, or a little bit less responsibility than Carl had. Those are some things to think about. So you don't want your RIFT employees' positions to be replaced. You want their positions to vanish. Now, they may vanish because that particular job function no longer is necessary, or it could be that those job functions are assumed by other people. So let's assume that when we get rid of Bob and Carl and Daniel, Sally and Amanda take over those jobs. So maybe Amanda takes over Bob's job, does her own job, Bob's job, and half of Carl's job. And Sally continues doing her job. She takes over half of Carl's job and all of Dan's job. That would be the classic example of a reduction in force work redistribution. See, I kind of already discussed this. We talked about how age discrimination, because again, in any given level within an organization, if an older worker is in that level, it oftentimes means he was passed over, she was passed over for promotion. But the younger workers haven't really had a chance for the promotion. So just as a matter of statistics, the older worker is on average going to be more likely to be a less strong performer. Another issue can be that as people age, they can gain in wisdom certainly and workplace knowledge, but they can also be diminished in certain situations. For example, let's say the job has physical components. They may not be as strong. They may tire more easily. They may miss more work because of illness issues. So there can be some reasons why an older worker may not be as productive as a younger worker might be. And so those can cause the older worker to be more likely to be subject to the reduction in force. We've talked about the prima facie case. Let's just look at it one more time though. In this particular picture shows it in two different ways. Let's consider it, I'm going to look at this one a little bit more closely. Okay, so first of all, because we're talking about age discrimination, we're only looking at people 40 and older, so that's the category of folks who would be able to make a prima facie case. So he was qualified for his job. He was meeting his employer's reasonable expectations. Again, he's a member of the protected class. He was qualified. He had an adverse employment decision. Usually we're thinking about a reduction in force, but it could be that he was demoted. So adverse action. And then this is the one that we are picking one or the other of these. Either other folks performing in his level who were younger were retained, or there's some other piece of evidence that makes us think that age was a factor in this. So let's go back to the example of we'll put it like this. So let's say that there are 4 levels within this organization, and the company's decided to get rid of everyone at this level. So that's a very clean break. But let's say that, actually let's not do it that way. Let's consider this. We have the 4 levels, but the employer has decided, they used to have 10 on this level, they decided to reduce it to 5. So they have 5 extra people. Now, sometimes employers will want to allow, let's say they look at the last 5 appraisals, and the 5 that have the weakest 5 appraisals are the ones who are going to, in this game of musical chairs, not have a seat. Well, now the question is, do we dismiss these people? Do we reduce them? Do we remove them from the payroll? Or do we allow them to bump people at a lower level? I mean, let's assume these people were promoted from this level. Well, they had to have been doing a good job down here at one point. There probably are some people down here who aren't doing a good job. So it might be reasonable to think, well, gosh, these folks could be better than some of the folks down here. Why don't we allow these folks to stay and then get rid of 5 folks down here? Now, employers have different ideas about whether that's a good idea or not. One school of thought is, look, these people are going to be mad and have bad attitudes no matter what we do. Better that we just don't see them anymore, and their bad attitude is somebody else's problem. If we demote them, they're always going to remember, I was demoted, I used to have the position, I don't have that position now. They're going to be that squeaky wheel, they're going to be that bad attitude, they're not going to be a good worker. Also, here, instead of affecting just 5 people, the 5 people that were in this position, we're affecting them in a negative way, and we're affecting 5 more people. So there's 10 people that we've kind of ticked off, and there's more coworkers here that feel affected by it. Let's say that there's a total of 20 people on this level. Well, 15 of them feel some level of, wow, that could have been me. Whereas up here, only the 5 remaining up here have that kind of feeling. And so it can cause, in a way, more workplace upheaval when you do allow bumping. On the other hand, certainly in a facility that has kind of a unionized tradition or that kind of mentality, there is a strong sense that, well, gosh, these people ought to be given the opportunity to bump. So you have to kind of consider the local culture and also consider, is that going to advance the business needs? For example, let's say that this is really an office job, whereas this is a production job. You've got to be spry, you're running, you're working, you're sweating, you're really hitting the pavement here. Well, these 5 folks that didn't make it in this position, they may not any longer be the kind of person who would be successful in this job. If they've been in the office job for 10 years, they may not be ready to hustle in the same way on the floor that other folks might be. So we already know this. The ADEA, the Age Discrimination Employment Act, prohibits mandatory retirement except for a few bona fide executives in high policy-making positions. Most employers don't even use those exceptions. So for the most part, unless you have some very safety-sensitive type jobs, there's not going to be any retirement age in the United States in the private sector at all. So as a result, you can't say, well, you ought to leave at this point, or this is going to be your last year. Again, there may be a very small portion of the population you can do that with, but it's pretty rare for employers to enforce that rule. Okay, let's consider the Older Workers Benefit Protection Act. This was an amendment by the Age Discrimination and Employment Amendment to the Age Discrimination and Employment Act. And it was designed to do a couple of things. First of all, it was designed to make it lawful for employers to offer voluntary retirement packages. So you can't have a required rule that a person has to retire at a certain age, but an employer can incentivize workers who might have an interest in retiring to go ahead and retire. And this can be done through a supplemented retirement package. These are perfectly lawful, and it's perfectly okay for an employer to give benefits to older workers that it denies to younger workers. Because again, there is no kind of reverse age discrimination type claim. What an employer cannot do with early retirement packages is it can't give those benefits to some of the workers and then deny it to people older. So you can't say, well, we're just going to offer this for workers between 55 and 60. We're not going to offer it to those under 55, and we're not going to offer it to those over 60. Well, their decision not to offer it to younger workers is perfectly lawful, but their decision to exclude 61 plus workers is unlawful. Now, their logic may have been, well, the workers who are 61 and older were probably about to retire anyway, and so we really don't need to incentivize them. They're going to do it anyway. That may be true, that may not be true, but whether it's true or not, the law says no. If you're offering it to the younger folks within that particular position or that particular unit or under those particular circumstances, you have to offer it for everybody older, even if you have an employee who is 71 years old, who you may think is going to retire any day now. Let's say that while you're drafting and considering this proposal, and as you can see, it's a pretty involved process, because it's obviously a pretty significant cost to the company to provide this augmented retirement package. The employer oftentimes doesn't really have a sense to know what percentage of the workforce is going to take it. You are going to be trying to make it appealing enough that the number of folks that you want to take it, but you also don't want to make it so lucrative that the company is spending unnecessary sums of money. Another factor can be that sometimes what happens in these packages is your best and brightest take it, because they can take the money and then run to the next employer. But the workers who are maybe less employable elsewhere, perhaps they have fewer skills, are the ones who decide not to take it because the package isn't so generous that they can afford to be without gainful employment, and they see this pace of employment as their best opportunity. So you can lose your most qualified, your most hardworking employees. So as you can see, this process of deciding what the package is and all the details of it can take months, certainly many weeks. And during this time, some of this population will be retiring on its own for whatever reason. And so the issue becomes, well, that population might say, well, I would have waited if I had only known that you were going to offer this. You withheld this information from me, and you should treat me as if I retired under this package. And generally, that's been a successful argument. The law does require that when a package like this is being seriously considered and is ultimately a go with the company, then you should look back and have picked a date. Okay, this is the date that we started really seriously considering it. Anyone who retires on that date or after is going to get the benefit of the package, even if he or she had no idea that there was a package involved at that time. So that again is going to be an extra expense for the employer to consider. Let's discuss bankruptcy issues. Obviously, when an employee is working for a bankrupt company or a company that's filed for bankruptcy, one of his big concerns is going to be, am I going to get paid? Am I going to work and not receive compensation for that? And that is a legitimate concern. There's kind of three categories to think about. One category of time is pre-filing is what we'll call this. This is when the bankruptcy filing happens. So, and then the next would be resolution of the filing. And of course, bankruptcies can result in a reorganization. The company can come back better and stronger and more successful after bankruptcy, or sometimes they decide to liquidate and there's no tomorrow for this particular entity. So if you're the employee, you're concerned about, am I going to get paid for that time that I worked pre-filing? And if I continue working for them after filing, am I going to get paid for this time? And will there be place for me to work after the resolution, or will this company no longer be in existence? Well, I'm not a bankruptcy attorney. I'm not going to go in, and even if I were, I wouldn't go into a lot of detail here because it's beyond the scope of what we need. Generally speaking, employees are not secured creditors. And so they don't have they're not first in line to get paid when there is a bankruptcy. But workers in this area, after the filing until the resolution, are given preferential treatment. So they're not in the front of the line with the secured creditors, but they're also not at the back of the line with ordinary non-secured creditors. The reason that they have some preferred treatment is that the company needs to be able to motivate workers to continue to show up. Because if workers don't show up, there's not going to be any business. There's nothing to save at the end. And so the employees need to have some feeling that, yeah, I am going to get paid. I think I am. I think that's going to work out. Otherwise, then the business is going to implode for sure. Employees before the filing, the work that they do here is still not they're not acting as a secure creditor. They're treated more like just a general creditor. Doesn't mean they're not going to get some money. If they have, obviously, if they've already been paid for the time, then it's not an issue. But it doesn't mean that they won't get some money, but some maybe cents on the dollar, 30 cents for every dollar they're owed, or something like that. So there's better treatment in this situation here than in this one. Then, of course, once the bankruptcy is done, they may or may not have a job here, but they just return to just ordinary payment situations under those circumstances. So when a union decides to file for bankruptcy, it's pretty common for the, not the union, I'm sorry, with the unionized employer files for bankruptcy, it's pretty common for the unionized employer to negotiate with the union to get some concessions, maybe lower wage rates, maybe other obligations under the contract. The union isn't required to agree to those, but the bankruptcy arrangements that within the bankruptcy court may require that those changes be made, and so a union may want to make concessions because it's at the table. It's having a role in choosing which concessions are going to be granted and which concessions aren't going to be granted. Obviously, if you're in this situation, you're going to be lawyered up on these points, so you're making sure that you're making the right choices in these areas. Okay, so now let's talk about post-termination issues. We already kind of talked a little bit about unemployment benefits. Obviously, if a worker loses his job, in other words, it's not a resign situation, but a dismissal, and he is able and available to work and seeking work, he is eligible for unemployment benefits as a general rule. Now, if he's fired for misconduct that is related to the work, or he resigns, or he decides he's just not going to look for work, he doesn't become eligible for unemployment benefits. The misconduct definition is going to vary from state to state. Most states find that the misconduct needs to be pretty serious. Certainly things like theft would be considered serious, assuming that there really is evidence of that. That's pretty strong. Things like tardiness problems or health-related reasons for absences are usually not going to work unless they're really severe, and that would be the tardiness situation. But maybe the reason that you were constantly late was because you were riding the bus. I mean, that was the only means of transportation. It's hard to call that misconduct. So usually there needs to be pretty significant evidence, and because the nature of unemployment is it's an insurance product, right? I mean, the word here is insurance. And so just like when you're in a car accident, you expect your auto insurance company to pay the claim even if you were at fault, maybe especially when you're at fault. And so the same logic applies to unemployment insurance. You ought to receive your payments kind of even if you weren't the best employee, or at least that's the logic behind here. A counterweight to that is that the employer shouldn't challenge unemployment eligibility unless there really is a basis legally to challenge it. So a worker who is subject to a reduction in force, even if he was chosen because he wasn't the best worker, he's somebody who is eligible for unemployment benefits. If you think that there might be severe enough misconduct that this person might not be eligible, of course that's not a downsizing type situation, but you would want to review the information in your state about how that process would work. As I said before, workers who resign are usually not going to be eligible for benefits, but as we talked about in a previous module, the concept of constructive discharge can definitely apply. So, for example, a worker who resigns because he or she was being sexually harassed at work might well be able to make a case for constructive discharge and be able to be awarded unemployment insurance benefits despite the fact that he or she was dismissed. Just so you'll know, generally speaking, striking workers are not eligible for unemployment benefits while they strike. Now, this does vary from state to state. That is the Texas rule, and it's the more common rule in the United States. But there are some states, these are typically in more unionized parts of the country, that do permit striking workers to apply for and receive unemployment benefits. Let's go back here. I'm just going to show you this website. I'm going to show you the link to this particular place. Here, this is the website for the Texas Workforce Commission, which is our unemployment resource, and this gives you information about how the unemployment insurance process works in Texas. So I'm not going to spend any more time on this website, but if you, as the HR person or the paralegal, are responsible for responding to unemployment benefits claims, you obviously want to become familiar with this in Texas if you are in Texas, and if not in Texas, obviously whatever state that you're working in, to find out what their standards are and what the paperwork looks like from that place. Usually attorneys are not involved in the processing of unemployment claims unless it's a claim that, or unless it relates to an employee who is likely to be asserting other claims, or perhaps a highly compensated employee within the organization. We've already talked about this slide. Unemployment insurance taxes are experience rated. This is similar to the workers' compensation idea. This is one of the reasons why an employer, even though we are an at-will state, it doesn't make sense to be arbitrary in dismissing people, because if you dismiss someone arbitrarily, hey, Bob, you're wearing a green tie to work today, you're fired. What? I don't like green ties. Oh, well, I'll take it off. Well, it's too late. You wore it to work. I'm firing you. But I didn't know. Well, that's too bad for you, Bob. You're fired. That type of decision making, obviously Bob is going to be eligible for unemployment benefits. Now, the way unemployment compensation works is not that the employer pays Bob directly, but what will happen is when that employer is next rated for its use of unemployment benefits, it will have one additional claim that was found to be meritorious. And just like when you get your auto insurance and you have an accident, even if it wasn't your fault, your insurance rates are probably going to go up. And so you get experience rated in that same way. As a result, most employers very much like to keep their successful unemployment claims to a bare minimum. Obviously, in a downsizing situation, there's nothing to do about it but suck it up. But you want to control it otherwise, and so therefore you do want to approach terminations from a due process / just cause perspective. Okay, now let's discuss restrictive covenants. This is a huge topic. And it's a very interesting topic in Texas, one that I've had the opportunity to be involved with several times in my career, so it's one of particular interest to me. I'm not going to do a deep dive here for a couple of reasons, though. First of all, this is a very state-specific field. So the answers that I would give you today really just relate to Texas and wouldn't necessarily give you much background in other states. The second reason is that Texas law is still evolving. We've had the same statute, which I'll show you in a second, for quite a while in Texas, but the Texas Supreme Court has interpreted those same ways in very, very different styles. There was a period of time initially where even though the language in the statute to the average person appeared to create the possibility of having enforceable non-competes in Texas, the Texas Supreme Court was very reluctant to enforce them. They always seem to find an excuse for not enforcing it, to be honest with you. And then I think because there was some turnover in the composition of the Texas Supreme Court, still quite conservative, but it was maybe a little bit less conservative. The Texas Supreme Court, I'm sorry, a little bit less liberal, because obviously non-competes are pro-employer, so I was talking backwards. The composition of the U.S. Texas Supreme Court became more conservative. Suddenly, the Supreme Court started approving or confirming that some non-competes were enforceable. Now, they did not overturn, I guess you could say they overturned a footnote in one opinion, but they did not really overturn a lot of decisions. They kind of did it by sleight of hand. They kind of, pretended like all these decisions are consistent with one another, despite the fact they're a little bit hard to reconcile. And since that, there was a big decision, it's called Sheshanoff, that happened in I think in 2006. Since then, there's been an increasingly, it's a slow but a steady movement towards more enforceability. We're still, in terms of most states, less likely to enforce a non-compete than other states. Even some of those more liberal states, honestly, than Texas. So we're not a situation where all non-competes are going to be enforceable, or the vast majority of non-competes are going to be enforceable, but still the dial has moved towards enforceability. So I hesitate to be too definite because the area of law is still a little bit uncertain. Plus, you may not hear anything more about non-competes for, in practice for 10 years, and the law may be very different by that point. So I don't want to give you a false sense of certainty about an area of the law that is evolving. So let's consider the topic of restrictive covenants. What is a restrictive covenant? Well, first of all, a covenant is an agreement between parties. Typically, we use the word covenant to refer to a section in a larger contract. So these are clauses within that contract. The clauses that, as you can imagine, restrict somebody. In this case, they're going to be restricting the employee. So they're contractual agreements that aim to provide employer interests, aim to protect employer interests by limiting the ability of former employees to do work for competitors, to disclose trade secrets, to solicit clients or former coworkers, or to make disparaging comments. Disparaging in this context means negative. They could be negative and true. So this isn't the same as defamation, which is negative and untrue. Now you can have a restrictive covenant that does all of these things, but we're primarily going to be focusing on this one. This is where most of the activity is. The other things really don't impact an employee who's left the employer dramatically in terms of his or her career prospects, but this one can be devastating to a person's employability. And that's the first category, the non-competition agreements. The restricted covenants designed to prohibit former employees from working for competitors. The general rule is employers should use non-competitive agreements only if important business interests are at stake. In other words, the employer has a legitimate concern about this employee working for a competitor, and the actual agreement should be as narrowly crafted as possible to protect that employer's interest. In other words, you should not limit the employee more than is necessary for the legitimate business interest of the employer. Let me give you an example. Let's say that I run a hair salon and I have 5 stylists, and our store is right here, and so we have our 5 stylists, each have a station in here. And I have all 5 of my stylists sign a non-compete, and they can't work for any other salon in the continental United States. Now my salon here is in Collin County. What are the odds that a person in Boston, Massachusetts is going to go from Boston, Massachusetts, travel all the way down to Collin County to get his or her hair cut? I would say that's 0%. So there really is no concern that I have about my stylist taking business away from me when that business is located in Boston, Massachusetts. I'm not going to have a piece of that business anyway. Probably people aren't going to travel more than 25 or 30 miles to get their hair done. No one's coming from Houston to come up to my salon in Collin County to get their hair done. So I guess one of the first things you're thinking about is, how big is the area from which I might draw my customers? And it's reasonable within that zone to restrict my employees from working for competitors. So let's say that I am in Frisco. It would be reasonable to restrict my employees from going to work for a salon in Plano, maybe even in Dallas. But it wouldn't be reasonable to restrict my employees from working in Oklahoma City or in Houston or in San Antonio, for example, because I'm not getting any customers from those places. And so that those would be the only benefit that I would get from restricting my employees, is that I might cause my employees to be really essentially unemployable, and therefore they feel like they have no choice but to remain in my employment. Well, that's not considered a legitimate business need from the employer. There's no protection of the clientele under those circumstances. As I said before, states differ widely regarding whether they will enforce non-competes. Some states will enforce most. California will enforce none. This is in the state constitution. Many people think this is one of the reasons why we have Silicon Valley in California, because if I wake up first thing in the morning, and I have a brilliant idea as I'm driving to work about, and let's say I work in the high-tech industry, and I think to myself, Eureka! I have just come up with the most brilliant product. And so I go in to see my boss as soon as I arrive and say, I quit. And I immediately go out and spend my life savings to build my workforce or my plant or whatever. And lo and behold, 6 months later, I'm a gazillionaire. Or maybe I'm broke. It could happen either way. But you can see that because in California they won't enforce the non-compete, my employer can't stop me. But if that same scenario happened in Dallas, and let's say I'm the same high-tech worker who has that eureka moment on the drive into work, I go in to tell my boss, hey boss, I'm quitting, I'm starting my own business. My boss might well say, no you're not, because you signed a non-compete. You can't do that, because what your product would be within our industry, it would be under the terms of the non-compete. I mean, it probably is, right? I mean, if I'm having a eureka moment and what I do is something in the high-tech industry, I'm probably not having a eureka moment about, pastries or about, a particular song that would be a big hit on the radio or whatever. It probably has to do with my industry, and so there would be a non-compete issue. So the unenforceability of non-competes in California is a big reason why there has been, or perhaps a big reason why there has been more innovation there. Another factor there is that people who are under the terms of a non-compete who want to be released from it move to California because they know that it's not going to be unenforceable. So let's say you have this worker, it wouldn't work with stylist obviously, but let's say it's a high-tech worker who is under a pretty ironclad enforceable non-compete in Texas. He can't work in Texas given these terms of the non-compete. Maybe it could even be enforceable outside of Texas, especially if it's a high-tech thing, because that's not really so tied to geography. Well, he may well think, you know what, I'm not going to be able to work in my industry until I can find a place on this planet that's not going to enforce the non-compete. Oh, California. Sounds good. I'm packing my bags. So another reason why California has been able to attract a lot of the high-tech industry. So here is the factors. And I said there's a lot of variation across the nation, and that's true, but much of the language that we see in the statutes and the case laws across the nation talk about the same things. Now where they come down on how tightly they enforce it can vary significantly, but what they're concerned about is the restriction reasonable in terms of geography, length of time, and scope of activity. So going back to my stylists, it would be reasonable for me to restrict them to 25 or 30 miles. It would not be reasonable to restrict them to the continental United States. It also wouldn't be reasonable to restrict them to the whole state of Texas. So you want to make sure that the geographic lines are reasonable given the client base. Oftentimes, if this is a sales position, it will be that you're restricted to not work in that sales territory that you've currently been working in. Now, in certain industries, there really aren't geographic boundaries, like the high-tech industry. I mean, a cell phone that I design in Richardson could be used in Taipei or Moscow or wherever. Any place on planet Earth would be potentially a place that my customers would be. So geographic restrictions in some industries don't make sense, but particularly in service industries, they can, like stylists. The time constraint is also relevant. With hairstylists, for example, people need to get their hair cut, every other month or something along those lines. And so if I have restricted somebody out of doing hair, say for 6 months or a year, all of that person's customers will have had to have found other arrangements for their hairstyle needs. And under those circumstances, allowing me to go back to work would mean I'm going to have to kind of start from scratch. And so therefore, I'm really not going to take any of your business. I'm getting my own business at that point. In the high-tech industry, time is also very, very relevant. What is cutting edge today may be passé in 6 months and ancient history in a year. And so therefore it doesn't make sense to restrict someone in a high-tech industry to 5 years because they're a dinosaur at that point in time. And then the scope of activity. I can restrict somebody, again, going back to my stylist business, I can probably restrict them from stylist services, from barber services, probably from color and permanent and relaxing services. But I can't restrict them from becoming a secretary or a brain surgeon or probably even a nail tech or a masseuse. Industries that are things that they're not already involved in. So you'd have to look and keep them within that, focus on, well, what tasks was this person doing for you in their job currently? Well, you can restrict them out of those tasks and maybe closely related tasks, but you can't make the restrictions so broad that you're making this person virtually unemployable. Many people are surprised to hear that non-competes are enforceable when the employee resigns his employment and also when he or she is fired. And even if he or she is fired because of a reduction in force or because of the at-will employment circumstance, the employee does not have to have engaged in malfeasance of some type. So it really doesn't matter typically in these agreements how that person came to be unemployed. So these three things are the things that we're going to look at. We look at them in Texas as well as most states. There is a second thing, though, that we need in Texas, and this is probably what makes our agreements more difficult to be enforced. And that is, in addition to being reasonable in terms of geography, time, and scope of activity, the non-compete clause has to be ancillary to or part of an otherwise enforceable agreement. And this is the language that has really been evolving lately. Let me show you the actual statute here, or at least an excerpt from the statute. The covenant must be ancillary to or part of an otherwise enforceable agreement, and the limitations contained in the covenant as to time, geographical area, and the scope of activity to be restrained must be reasonable and impose a restraint that is not greater than necessary to protect the goodwill or other business interest of the promise. So this is just a flavor about what the statute says. And again, other than this section, the rest of the statute you'd probably find in, 30 or 40 other states. So the takeaway here is before you draft a non-compete and before you attempt to enforce a non-compete, you'll definitely want to get a Texas-based employment attorney to evaluate it. Because again, this really requires very specialized knowledge that is Texas-specific. In addition to the non-compete, non-competitive agreement, we also have the non-solicitation agreement. This is when former employees are prohibited from soliciting the firm's clients after the employee leaves. Usually these are a little bit more easy to enforce because they're less restrictive on the employee's professional life. A trade secret is let me pause and talk a little bit about trade secret here. We think about trade secret, or we think about trade secret as a type of intellectual property, and we think about there really being 4 categories of intellectual property. We think about copyrights, which are artistic accomplishments or artistic work. We think about trademarks, which are the way that a business presents itself, like the swoosh on Nike or the golden arches for McDonald's, that type of thing, or the half-eaten or an apple with a bite missing out of it, as in the Apple logo. So those are the trademarks. Then we have patents, which are inventions. Things like if I were designing a new a fishing pole, and I might come up with a new technology to thread the fishing wire through the pole in a way that is quicker and more efficient and less likely to get tangled up. That would be an example of something that could be patentable, some invention. And so those are the first 3. The fourth one is trade secret. And this one is mainly a creature of common law. Although there are some statutes that relate to it that we sometimes arise, it's most similar to the patented idea. An example of a trade secret could be the 11 secret 11 herbs and spices that Kentucky Fried Chicken uses in its chicken recipe. Generally, generally recipes cannot be patented, and so or subject to copyright, and so the business has a real incentive to go ahead and really lock down information associated with it so that the world doesn't find out about it. Same way with, say, the secret formula for Coca-Cola or whatever the recipe might be. So a trade secret refers to information that has actual or potential economic value because it is not generally known to others and the owner makes reasonable efforts to keep the information a secret. The duty to keep trade secrets a secret falls to employees even without a non-compete or some other type of agreement. Courts have recognized the duty of employees under common law not to divulge such information. It's under the duty of loyalty. The employer is sharing information to you so that you can accomplish the business that the employer has assigned to you and that you've agreed to take on for compensation. The employer isn't giving you this information so that you can sell it to competitors or some other entities. And so this is an example of trade secret. So you don't actually have to have a covenant for the employer to have the ability to enforce some trade secrets. Examples of trade secrets could be special processes that a manufacturer uses. It could be customer lists or certain techniques that an employer uses to generate sales. Those could be trade secrets. So at this point, we have completed our topics. Here's some things to keep in mind. Let's refresh. We talked about downsizing and how a unionized facility raises special issues in that context. We talked about complying with the Warren Act and giving those 60 days notice. We talked about the special concerns relating to age discrimination in employment. And of course, you can also have downsizing concerns when women are disparately impacted by a reduction in force, or when particular minority groups such as African Americans are disparately impacted or more likely to be laid off than other ethnic groups, or of course it could be a national origin or a religion claim under those same areas. We talked about the difference between disparate treatment and disparate impact previously in other units, but that analysis certainly applies in the downsizing scenario as well. Then we talked about the bankruptcy issues of how employees will be paid if their company files for bankruptcy. We talked about unemployment benefits and a variety of restrictive covenant types and how those work in Texas. Let's consider some takeaways to reflect upon when you are forced into making some of these difficult choices. So when a mass layoff is necessary, you're definitely going to want to involve legal counsel to make sure that the selection criteria is carefully made. You're going to want to apply those criteria consistently. You're going to want to check for disparate impact. You're going to want to crunch the numbers and see, let's say your workforce is 45% women, but 70% of the people who are being laid off are women. That's a pretty strong disparate impact. You're going to want to look at the statistics, and then you may want to reflect upon, were your criteria really objective? Or was there some criteria in that happened to make it more likely that women would be impacted than men? Same way with racial dynamics, national origin dynamics, and age dynamics. You may want to consider providing severance benefits in exchange for a waiver, and of course you're going to want your waiver to be Older Workers Benefit Protection Act approved. We talked in the age discrimination module about the requirements that are necessary for a compliant Older Workers Benefit Protection Act waiver. Things like giving the employee a certain number of days notice, giving him the opportunity to retract his agreement, the things that have to be in the contract. And you may recall that when it's when it's a larger downsizing, you have to give the employer longer periods of time, and you have to give the employee longer periods of time, and you have to give the employee some pretty detailed notice about who else is being affected. The reason for this is that the employee needs more information to accurately evaluate how strong his claim might be, and this data helps him or her have that information, and it gives him or her the opportunity to seek legal counsel to decide whether the reduction in force is something that he wants to contest in terms of choosing not to sign the release, or is it in his best interest to go ahead and sign the release? You want to be sure that you follow the WARN Act if it's a WARN Act covered downsizing event, and if the workforce is unionized, you want to be sure that you are not committing an unfair labor practice by how you're administering the layoff process. Generally, in a mass layoff, you're not going to want to contest unemployment benefits. And when you're considering the use of non-compete or non-solicitation agreements, especially in Texas, you are definitely going to want to involve a Texas employment lawyer to see if what you want to do is going to be okay under Texas law, and if it is okay, how broad you can make that scope, and what are the special concerns that you want to be aware of as you draft that and as you consider communicating it to employees and enforcing those types of agreements. Well, I hope that this presentation has been helpful to you. As always, if you have questions about the material, please don't hesitate to contact me. My email is cgroover@collin.edu. It's been a pleasure making this Oh, also, by the way, come and see me if you'd like to talk to me in more details. This can be a very, very interesting topic. Obviously, it's an unfortunate topic when you're talking about people losing their employment, but it is an intellectually interesting and complex area that, if done well, can very much protect the interests of the employers and sometimes even the interests of the employees. When done poorly, it can be very, very costly for everyone. I thank you for your attention, and I hope you have a wonderful day. Take care.